osteoporosis, depression, fatigue. It's all in this very informative book that's yours free when you call and order today. So, folks, this is a really great offer. Again, you get to try CalMax absolutely risk-free. Be one of the first 100 callers. You're going to get that extra free bottle, plus you're going to receive the free book. The number to call is 1-800-488-8129. And look, you have absolutely nothing to lose here because you get to try CalMax absolutely risk-free. The number to call is 1-800-488-8129. I'll give it to you one more time. It's 1-800-488-8129. Well, that's all the time we have for today. Please join us again next week for another edition of Discoveries in Health. Until then, I'm Chris McKay, wishing good health to you and your family.
She's smart, beautiful, and a former Fox Business Channel host. Now you can hear her take on the day's financial news on The Trish Regan Show on the Salem Podcast Network. Portions of this hour have been pre-recorded for broadcast at this time.
SRN News, I'm Bob Agnew in Washington. Thousands of people braved the cold in the nation's capital on Friday for the annual March for Life. House Speaker Mike Johnson was among the speakers. He told participants his own teenage parents chose to keep him even though he was unplanned back in 1972. He says U.S. should do more to promote a caring environment for pregnant women. Donald Trump spoke at a campaign rally last night in Concord, New Hampshire, predicting victory for his campaign in next Tuesday's New Hampshire primary. Senator Tim Scott was on hand at that event, giving his endorsement to the former president. A new large vehicle underpinning announced by Stellantis on Friday, key to the company's ability to adjust to European and U.S. government electric vehicle requirements. That could change depending on this year's elections. According to the company's new platform, they're prepared to go with either electric or gas-powered engines. This is SRN News.
WTVN Pinellas Park, WLCC Brandon.
Faith Talk Tampa. Online at letstalkfaith.com. Download the Faith Talk Tampa app.
The battle over religious freedom will continue in Finland. Here's Michael Harrington.
In a case that has attracted international attention, the government is trying to punish a Lutheran bishop and a Christian member of parliament for stating that homosexuality is contrary to the will of God. Two lower courts have unanimously ruled in favor of Bishop Juhana Pohola and MP Pavi Rasinen. The government is now appealing the case to the Finnish Supreme Court. The two were accused of violating hate speech laws. Michael Harrington, SRN News.
Alabama has begun enforcing a ban on the use of puberty blockers and hormones meant to help children live as the opposite sex. The 11th U.S. Circuit Court of Appeals has granted the state's request to stay a preliminary injunction that had blocked Alabama from enforcing the 2022 law. The state attorney general, Steve Marshall, calls the order a, quote, significant victory for our country, for children, and for common sense. This is SRN News. President Biden and Israeli Prime Minister Benjamin Netanyahu spoke directly on Friday for the first time in nearly 4 weeks about President Biden's encouragement for a two-state solution for peace. Here's correspondent Ben Thomas reporting.
The president still believes in the promise and the possibility of a two-state solution.
Fundamental differences have emerged in the two leaders' visions for Gaza once Israel's war with Hamas ends.
Good friends and allies can have those kinds of candid, forthright discussions, and we do.
National Security Council spokesman John Kirby.
It's not going to change the president's view that the best long-term solution for regional security, particularly the security of the Israeli people, is a free and independent Palestinian state.
Netanyahu says he's told U.S. officials in plain terms he opposes the establishment of a Palestinian state as part of any post-war plan. Kirby again.
You can't do that without also talking about the aspirations of the Palestinian people.
More on these stories at SRN News.
The following program is sponsored by the law offices of Patrick L. Smith. This is the Attorney Patrick Smith Show. Get ready with your legal questions and call Patrick now. 877-943-9673. Again, that's 877-943-9673. The law office is open. And now your host, Patrick Smith.
Good morning, and welcome to another edition of the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. All right. That music music, it's a little too much sometimes. So 877-943-9673. 877-943-9673. Give us a call now. The law office is open. I'm your host, Attorney Patrick Smith, and this is the Attorney Patrick Smith Show, your one-stop shop for all things legal. Should you be in need of legal advice this morning, you can give us a call now. We are live and local, open studio lines, happy to help any way that we can. No legal subject off limits. So call in now with your legal query and we'll be happy to assist you as best we can this Saturday morning, January 20th. It feels like July already. It's been a year. January's certainly been a very, very busy month for us at the practice. And we're always happy to take a break from the typical client meetings and meet with you over the air every Saturday morning. So 877-943-9673. 877-943-9673. That's your number to be part of today's studio line. If you want to call in, we'll get you queued up to talk to me live, ask your question, and then you and the rest of the listening audience can sit back and benefit from the answer. You can also always email your questions, patrick@attorneypatricksmith.com. Today we're going to discuss some new legislation kind of hitting the state of Florida, some that's already gone into effect and some that is potentially going into effect. So sort of the theme of today's show in between your calls and questions, and you can be part of the show anytime. And by the way, if you have a topic, this was actually a listener suggested topic for the show and kind of a follow-up piece. You'll see what I mean here in a few moments, but it is always an open forum here at the Attorney Patrick Smith Show. So if you have an idea or a topic you would like to hear discussed, reach out. Just let me know. Drop me an email, patrick@attorneypatricksmith.com. So this past week, we had a near tragedy. According to WFLA, we had 3 teens hurt in a golf cart incident on Dale Mabry. Actually, at Dale Mabry and West Dale Mabry Avenue. According to WFLA, the police said the golf cart was heading east and tried to cut across all lanes of traffic. The driver of the vehicle slowed to avoid hitting them, but did not stop in time. And it was a Honda that collided with the golf cart. And in that battle, the golf cart is always going to lose, and the 3 teens were ejected. No other information. Teens were treated for minor injuries at the scene. And this was also apparently around 7:30 p.m., which is dark, so I'm not really sure what we're doing out on a golf cart on Dale Mabry at 7:30. But I say that to say this, to remind everyone there is a new Florida law in effect regarding driving golf carts. First of all, the previous law, you were allowed, anyone 14 years or older in golf cart communities was allowed to operate a golf cart on public roadways. The new law, though, in effect as of 2023, that law says now you must be in possession of a learner's permit if you're 15 years or older, a driver's license at 16 or older, or otherwise be 18. So new laws in effect regarding Florida's golf carts. Know those laws. And, we live in Indian Rocks Beach, and definitely a golf cart-friendly community, and we still see it from time to time. Very, very young children bebopping around the community in golf carts, and it's dangerous, especially when there's a lot of construction in the neighborhood. There are these tight turns, and you have inexperienced drivers driving golf carts on the roads competing with automobiles and construction equipment, so it's just a recipe for disaster. So make sure you know those laws and you enforce them with your children, and make sure they're obeying those and not operating a golf cart at too young of an age where they could get themselves or someone else or all the above injured. So again, the new law, if you're 15 years or older, you can drive with learner's permit, the golf cart legally in the state of Florida. At 16, the driver's license is required, or otherwise be 18 years of age. 877-943-9673. That's your live and local number. Maybe you have a golf cart law question for us this morning. You can call in now, 877-943-9673. Toll-free open lines. We'll get you right on the air to ask your legal question. And you can always, again, email us, patrick@attorneypatricksmith.com. I want to say a very special thank you to Indian Rocks Church and Indian Rocks Foundation for hosting my Wills and Trusts seminar this past Wednesday evening, and we had an absolutely massive turnout there in the educational center, and to the point where Pastor Ray and Joe were bringing in chairs, and we basically had the aisles filled with chairs by the time we were in the midst of the presentation. So always a great turnout at Indian Rocks, and if you have a club or group that could take advantage of having us come and speak to your organization, you can always book us by going to the website, attorneypatricksmith.com, and lots of groups booking. I know I just booked a veterans group yesterday that wanted to hear me speak on a particular issue. So if you have a group or organization, church groups are extremely popular like Indian Rocks, but charity groups are big as well. You're welcome to call and book us absolutely free of charge. We'll come and speak to your organization, and if you have a particular law or legal topic you would like to hear discussed, we will custom prepare a presentation for your group. Again, you can reach out directly to the office line. This is the office line for those of you who like the office line to be given out during the show. Here you go. Here it is the first time this broadcast. 877-754-6764. Again, that is the toll-free number to reach our office line throughout the week. Monday through Friday, phone lines are open 8 a.m. to 4:30 p.m. That number to book us to come and speak to your club, group, or organization, or if you want to schedule your complimentary estate planning consultation, 877-754-6764. That's your toll-free studio line. I want to talk next about a development, I would say, that I'm noticing in the practice. And there is this phenomenon going on where parties are passing away, and that's not the new thing. That's happened forever. But the new thing I'm noticing are personal representatives who are being selected by family to serve in that capacity. Sort of observing the fact that, okay, I've been picked as personal representative, and there's sort of like this trophy mentality. I've been picked. I'm the PR. I've won. And treating it sort of as a finish line. And just because you were selected as personal representative doesn't mean that you're finished. That's actually the starting line. And so I thought I'd spend a couple of minutes today talking about if you've been selected or if you're nominated, if you know that when your parents pass away, you're going to serve as their personal representative, sort of what can you expect? Just sort of from a practitioner standpoint, observing a lot of people coming into this thinking, I'm going to be the personal representative, and that's it, and then there's nothing else to do. Well, there's more to it than that. So if you are the personal representative on someone's will, and you are in fact doing a probate under that will, the first thing you will do is typically consult with an attorney about hiring that attorney to help you through the court-supervised probate process, and that would be either through a summary administration if it's an estate of less than $75,000 outside of any exemptions, or over $75,000, it's a formal probate. And then you sort of have this relationship that's created where the attorney and the personal representative are standing back to back. The attorney is facing the courts and the laws and making sure that all those are obeyed and observed and not violated, all deadlines are met, and you timely file everything that needs to be reported as part of the normal probate process. But the personal representative is not on easy street at that point. The personal representative has the following task: marshaling all the estate assets. That means going out, boots on the ground, figuring out where all the money is, how many pieces of real property, which bank accounts, which brokerage accounts, where do we need to go to find that CD or bond or whatever may be out there in the decedent's name. That can be some work, and you, as a planner of your own estate, can make this much easier for your personal representative by keeping a list of those assets and updating it periodically from time to time. But let's say you've gone out as a personal representative, you gathered everything together. Are you done yet? No. Next step is you got to pay the bills. There's a process in the probate proceedings called a notice to creditors where you publish over this 90-day window and claims get filed. Now, if a claim is filed, your attorney will let you know, and you have an opportunity within 30 days to object if you don't think that's a valid claim. If you object, then the creditor has two choices: go away or file a suit basically through independent action regarding that claim. All right, so you've paid the bills. All the bills have been satisfied one way or the other. Are you finished now? No. You still have taxes to settle because he is personal representative. You're personally responsible for the decedent's final tax return. So you get all the taxes together, you get with your accountant, and you settle the taxes. Are you finished yet? Nope, there's still a couple more steps to go. You have a fiduciary duty as personal representative to provide what we call a formal accounting to your beneficiaries. That's where you show them everything. Here's everything I gathered. Here's everything I paid in the way of bills, reimbursements, the personal representative's fee, which is typically around a 3% fee according to the statutory guidelines, although that's not binding. You also have the attorney's fee. You have all the hard costs, the taxes, and you give them a breakdown to show them what your planned intent of distribution is. And then the beneficiaries have a 30-day window to review that, question it, consent to it, or object. Then you do the distribution pursuant to that accounting, presuming there's no objections filed. If there are objections, obviously you could have resulting litigation or a hearing regarding that. But presuming no objections, then you have the distribution pursuant to that accounting, and each beneficiary receives their share, signs off on a receipt of distribution and a release of personal representative, and then you, through your attorney, file something called a petition for discharge, and you'll receive what we call a closing letter from your attorney. The attorney will tell you our case is closed, you're finished, here's your discharge order, job well done. But a little round out on sort of what the personal representative, because I had so many parties sort of coming in and asking questions during presentations regarding this and thinking, well, once I'm picked as the personal representative, I can sort of do whatever I want, whenever I want, however I want, and that's not correct. I mean, first of all, being a personal representative is kind of like being a quarterback in a football game, and it's topical considering we have divisional playoffs this weekend. As the quarterback, you have to run the play the head coach called. Well, in this analogy, the head coach is the decedent. So they called the play, and you sort of have to follow that play as the personal representative. You can't deviate from that. You have to do what the decedent's wishes detailed. I mean, probate literally means to prove the intent of the decedent. So within that, you can't really do much as far as deviating from that without violating some potential statutes regarding prompt administration and avoiding maladministration of an estate. So you want to make sure you get with a good attorney, you have a good consultation, and you make sure that you get pointed in the right direction to follow the rules under the statutes and don't get yourself in trouble. Maybe you are in that spot currently as a personal representative and you're not quite yet represented by counsel, or maybe you're in the process of selecting a personal representative. That's another dynamic we're seeing where families are struggling. Which child do we pick? So maybe you're struggling with that. 877-943-9673. That's your toll-free studio line. This is the Attorney Patrick Smith Show, and I'm your host, Attorney Patrick Smith. 877-943-9673. You can give us a call now. We are live. We are local. We are happy to help any way that we can. And so families are saying, well, if I have 3 kids and I put one of the children in charge, won't it offend the other 2? Maybe. It does occasionally from time to time. I do notice that. But I also notice this phenomenon where the kids don't have their feelings hurt too much as long as they figure out they're still getting an inheritance. Where we see the hurt feelings is where the kids find out they're being disinherited. Obviously, that would sting a little bit. But where you find out you're not the PR, you just found out someone else has to do all the work and you get to sit back and check their report in the accounting and you still get your inheritance. Not being the PR is not the worst position in the world. Not being a beneficiary, completely different bag of goods. So, we want to make sure that you select a good PR. A lot of times that's why people go outside of the kids. When the kids are the beneficiaries, they'll pick some third party who's not one of the kids. And that way it was a neutral party that was selected. And you especially see this in blended families. So in a blended family scenario where it's his kids, her kids from previous relationships, and you don't want them to feel like one is favored over the other. Picking a neutral party there can go a long way to ameliorate a lot of potential conflict, doubt, concern. So selecting a personal representative, a very critical step for multiple reasons in your estate planning process. If you have a legal question for us, 877-943-9673. And I did say today we are discussing new legislation. We started off the top of the show reminding you of Florida's new golf cart law, reminding you that at the age of 15 to operate a golf cart legally in the state of Florida, you must have a learner's permit at 16, the driver's license, or otherwise be 18 years of age. And this is in light of the unfortunate accident that happened on Dale Mabry back earlier this week involving 3 teens who cut in front of a Honda there at Dale Mabry and West Dale Avenue. So new laws being our theme of the day, we're going to talk next about Senate Bill 280, which is a proposed new bill regarding vacation rentals in the state of Florida. And joining us now on the hotline, the author of the bill, a friend of our show and a regular guest to the show now, Senator Nick DeCiglia. Nick, welcome to the show. Welcome back to the show, I should say.
Good morning. It's good to be back.
All right, Nick. So Senate Bill 280, a lot of people are calling it, 740 2.0, because I think that's a fair assessment of the bill. Would you agree?
Yeah, we had, Senate Bill 714 last year, got off the House floor, which, essentially, created a uniform set of regulations for vacation rentals across the state. And then, if you remember, the House amended that framework, essentially gutted it to give relatively zero regulatory authority for local governments to manage and regulate vacation rentals, send it back to the House, and then we killed it in the Senate.
Yeah, that was where I was keeping tabs on this bill and the legislation. And for those of you not familiar with this part of the show, we've tracked sort of the short-term rental controversy throughout the state of Florida. We talk about it in Indian Rocks Beach because, Nick, you and I both live in Indian Rocks Beach, but, Anna Maria Island, there are lots of other communities that were affected by the vacation rental saga. So your legislation is an attempt to address this at a statewide level. And just talk to me a little bit about why you saw the need for this particular piece of legislation.
Yeah, so first I want to clarify that the vacation rental has already been preempted by the state back in 2011. That preemption was slightly relaxed in 2014. As you can well imagine, it's been 10 years. The industry has dramatically changed over the last 10 years. We've seen, I would say, somewhat of an inconsistencies across the state when it comes to these ordinances. Indian Rocks Beach, for example, passed their new ordinance in May. That went into effect in August. 8 lawsuits were immediately filed. It's my understanding that that's already been mediated, and certainly don't know the details of that, but common sense tells me, I would not be surprised if the city has to come back and relax some of those, ordinances and regulations that they put in place in August. So when you have these inconsistencies that, quite frankly, is not in balance with with the platforms, with the property owner, you have a tendency to invite this type of litigation. And, from a standpoint, someone who serves in the legislature, I take great concern when we have these inconsistencies that invites these lawsuits, potential Bert Harris claims, which could ultimately bankrupt a local government. That to me it makes it appropriate where the state comes in and tries to set a consistent regulatory framework in relation to vacation rentals. And it's not just in Indian Rocks Beach. There's, like I mentioned, across the state, in some of these jurisdictions, there's been, litigation after litigation after litigation. And, those taxpayer money has to defend those lawsuits, as you well know. And I think that putting something that is uniform, it creates predictability for local governments. It creates predictability for the residents that live in these communities, and it creates predictability for the individuals that want to exercise their property rights. And so there's a lot of moving pieces. There are a lot of stakeholders here that, in finding that balance, I think we're going to get into a situation where, in fact, we are going to, give those tools to local governments to regulate it, the noise, the parking, and the trash, all at the same time, not infringing on anybody's constitutional rights.
Well, and what I applaud that you're doing here, Nick, more than anything, is finding some sort of common ground. And I think that's what great politicians do, is they say anybody, any schmo can focus on our differences. But I think a great politician and a great statesman or statesperson can find the common ground. So I think that's the issue here, is where can we find that sort of balance point where property owners' rights can balance between those vacation rental owners and the private residents who live down the street. There has to be, because everyone can agree. And this was sort of my critique of the controversy as it unfolded in Indian Rocks Beach, was we really don't have a vacation rental problem, in my opinion. We have a behavior problem.
Yes.
And the behaviors are what we really have a problem with. Do you have a problem that a vacation rental is next door? We had one across the street from us. And we never had any issues because the behavior of the renters were great. We didn't have them, partying and making loud noises at 3 a.m. Not every neighbor was so fortunate. But my point being, if that was a neighbor who had lived there 50 years and they were having a loud party at 3 a.m., it doesn't somehow justify it just because they're a long-term neighbor and not a vacation rental property. So I think that that's kind of the point, is if we can get the behaviors under control, and I'll come to that point in the legislation that you're proposing, but one of the first big sort of points in your particular legislation, and correct me if I'm wrong, Nick, but I did read the legislation, and as I read it, the new Senate bill could prohibit the local governments from regulating occupancy to require certain maximums. Now, that was one of the big subjects that was discussed in Indian Rocks Beach at town hall meeting after town hall meeting, was what were the occupancy limits going to be. So maybe talk a little bit about how Senate Bill 280 addresses local governments who are imposing occupancy limits on these short-term rentals.
Yes, that's a great question, and you're right. To your earlier point, the biggest challenge here is finding and striking this balance. I obviously, have serious concerns with these party houses. That is the crux of the issue here. Speaking to occupancy, we just filed an amendment. The bill was in Fiscal Policy Committee on Thursday. We filed an amendment that did a few things really quickly. Number one, we had a $150 cap for the registration fee for the local registration. We moved that $150 fee, that cap, to a reasonable fee. This is going to allow local governments to charge what they feel is an appropriate registration fee, so that they can, in fact, use those funds to enforce the regulations that they put in place. We also, because occupancy is an important thing for me, and I expressed this to the Senate President, I expressed this to committee staff, obviously to my colleagues. So the bill was amended to basically tie occupancy to the local fire code. To the state fire code. We have a state fire code. It is one person per 150 square feet. That's a lot of people. I mentioned that in committee. I'm not there yet. I think we have some further work to do there. I think the concept that I like, and I don't know what that sweet spot is, but for example, 2 people per room plus 2 in a common area, plus 4 in a common area. I think it's very consistent with what Indian Rocks Beach has done. I think their cap right now is 12. And so, to find that sweet spot, is an important piece for me to get to a place where, I want to see this legislation ultimately go through the legislative process, because, we can sit here, yes, we talk about property rights, we talk about, the needs of local government, and all of that is correct. But we cannot kid ourselves that if we don't recognize that the biggest issue we have here is a bunch of people in a property making a lot of noise. It's much easier to regulate that if local governments know exactly how many folks are allowed to sleep in an accommodation overnight. And the bill also requires the property owner to list the maximum occupancy that they're setting for that rental. In order for that to be consistent, I believe we need to set those limits and then set those limits within this legislation.
All right. If you're just joining us, that's Senator Nick DeCiglia, who represents the state's 18th district, our state senator for Pinellas County, and actually my state senator there in Indian Rocks Beach. And we're discussing his new proposed legislation regarding vacation rentals, Senate Bill 280. And Nick, to your point, I'm happy to hear that, because some of the criticism when I'm researching this, some of the criticism was regarding that cap on the initial inspection fee of $150, and then I think that there was a cap of $50 in the bill on the renewal fees. Now, you mentioned that you proposed an amendment in committee that was going to basically say that's going to be a reasonable fee. Does that reasonable fee language apply to just the initial fee or to the renewal fees as well?
Great question. So it actually applies to 3 things. Number 1, the registration fee. Number 2, the renewal fee. And the third piece, which has been in the legislation going back to last year, is for the annual inspection. And so, those those reasonable fees. Again, the feedback that we have gotten was that, well, I think Indian Rock Beach charges somewhere in the $400 range. That those funds again go towards enforcement. Now, I will say that all that being said, and this is something that isn't discussed very much. These are non-homesteaded properties, and because these are non-homesteaded properties, there's a significant number or a significant amount of additional taxpayer revenue that comes into a particular municipality because they're not homesteaded. And so, despite that fact, we still thought, let's go ahead and allow local governments to set those reasonable fees. And I think a backstop to that is last year's Senate Bill 170, which ultimately require local governments to provide a economic impact statement with some of these fees. So, in other words, a municipality can't go and charge $10,000 for a registration fee, where in fact that $10,000 is simply used to prevent that property from operating at all. So we've got some checks and balances there, which is, as you well know, a key part of our system at the state and federal level, for that matter. This is about taking that feedback and translating that into that middle ground that you mentioned earlier.
We're talking baby steps. I mean, we've got to make these baby steps so that we ultimately find the solution, and we can't let perfect be the enemy of better. Right now, we can be better. We don't have to be perfect right away. We may never reach perfect, but as long as we're striving for better in this legislation, I think we're going to improve everyone's blood pressure by a few points. Now, and I'm glad to hear you say that about the reasonable fee because, I live in a world of reasonable fees. We do trust all the time, and trustees are paid what we call reasonable fees. That's what the statute says. And I think that for me, and that sort of addresses one of the other big criticisms. Well, if you're going to cap our registration fee at this, 150 or 50 or whatever it was, then you're sort of limiting our ability to defend against these lawsuits. If we have, like you said, 8 or 10 or 30 lawsuits pop up, maybe we need to raise the fees on these registrations to be able to counterbalance the litigation. So maybe that could be the determining factor in what's a reasonable, because if you had a sleepy community where there are no controversies, no lawsuits, those fees could be less. If you have one where there's, like you said, 30 lawsuits or something like that, maybe the fees are more. And so that reasonableness, I think, sort of gives the local municipality sort of to self-regulate, sort of that home rule argument about what their fee is going to be in light of the litigation that they're experiencing, because litigation is certainly a likely, if not certain, outcome in response to any legislation that's passed.
No, that's correct. And I think, again, that's a great point. And I'll kind of build on that where, if this were to be put in place, the local governments aren't necessarily responsible, for those regulations. It would be the state. So I would assume that the litigation would be, towards the state at that point. But, hopefully we can get to a place where, again, there's this predictability where, the operators, local governments, the residents, that everybody understands what the parameters are, what the limitations are. And again, in the bill, we clearly lay out, suspension. We clearly lay out how many violations of local ordinances would prompt a suspension. We tie that in with the Department of Business and Professional Regulation, which currently and has always been the ultimate regulator here. And to make that consistent, I think again is good policy. The department has also asked us for in the range of $3.5 million for budget allocations to manage the program. They're looking to hire 9 full-time employees. We've also are going to require them to have a database where every single vacation rental property is going to have its own unique license number at the local level, at the state level. Every jurisdiction needs to know of each vacation rental property that's operating in their city. They absolutely have to know that.
Well, I think that's a good point. I mean, from a safety perspective, too. So, Nick, do you have time to take some calls? We have some callers calling in with questions.
Sure.
All right. So if you have a question for Senator Nick DeSiglia, representing our 18th district, we're discussing his bill, Senate 280, regarding vacation rentals, 877-943-9673, 877-943-9673. This is Attorney Patrick Smith, and you're listening to the Attorney Patrick Smith Show. Let's go to a very patient... Well, hold on. First of all, is that Vern? Vern, is that you? Hey, Vern.
Yeah.
Is this Vern?
Yeah, it's Vern.
What's going on, Vern?
Oh, hey there. I was going to talk about golf cars, but yeah, it's me.
Okay, well, I saw you jumped to the top of my list. I just want to make sure, is everything okay down there? This is our producer, board operator in Sun City Center on Sun Radio, your community radio, right, Vern?
That is it, and we are also a golf car community. But if you want to take care of the senator first and pull me back, because there's just one or two corrections I need to make to what you said about the golf car law.
You want to correct me in front of a senator?
I can do that.
All right, go ahead. I'll allow it.
Okay. You're right about the part about 14-year-olds cannot drive golf cars anymore.
Well, that's all we have time for today, Vern, unfortunately. No, I'm just kidding. Go ahead, Vern.
You're also right about 15 and 16-year-olds, or 15-year-olds requiring a permit, and 16 if they don't have their driver's license yet. That part is correct. What you missed is that the 15-year-old must have a licensed driver, just like they do in a car. And if they don't have a driver's license yet, if they're 16 and they're still operating on a permit and they haven't got that license yet, they still have to have a licensed driver. Now, that's not grandpa with a state ID or something like that. It's a licensed driver has to be with that 15-year-old or 16 who hasn't gotten his license yet, has to be there. Then at 18, that goes away. All you need is an ID, but there also is a requirement from the state now that people over the age of 18, while they don't necessarily need a driver's license, they do need an ID, some sort of an identification card, hopefully with their picture on it, because you never can tell when something's going to happen, and they need to identify the person. Other than that, it's 100% correct. That law has changed.
Other than the part that was wrong, it was 100% right. So it's a little bit like 60% of the time. It works every time. All right, Vern. Well, I appreciate the clarification, and thank you so much for calling in, Vern, and thank you for all you guys do down there on Sun Radio 96.3, right?
Yeah, it is it. Sun City Center. Thanks, buddy, and I just wanted to make sure it's right, because I don't want anybody in trouble.
All right, Vern, we appreciate you. Bye-bye. All righty, this is the Attorney Patrick Smith Show. Joining us, Senator Nick DeCiglia. We are discussing Senate Bill 280, but anytime Vern calls in, I mean, he gets to jump to the top of the list. Vern's one of our special guys. All right, a very patient Kevin in Bradenton. Kevin, you have a question for Senator DeCiglia. Go ahead.
Yes, I'm talking about that. Let me scroll back up to the top of it. The Renters House Bill 985 that somebody's trying to put through. It worries me as a landlord. Some of the language, the rental agreement must be in the language preferable to the renter. And the big one I see right now is if you do not renew the lease, you have to provide rental assistance to help them move.
Yes, this is proposed legislation, and this is over in the House. And Nick, you're in the Senate, but is there a Senate version of this House Bill 985? I'm pulling it up in real time. Kevin, we were discussing 280, but I agree with you. This is sort of a sister bill, kind of.
Well, let me clarify. I got my computer in front of me here, so there's a couple things. Number one, House Bill 985 is housing. Doesn't speak to vacation rentals, and I can tell you, just looking at that the House sponsors on this bill is not going to get a committee hearing. So whatever's in this proposed bill, you don't have to worry about this at all.
What I hear you saying, Nick, is this is proposed by Democrats, and the Republicans are running the committee.
You are correct.
Okay, it's like I've read the tea leaves before. By the way, I do want to point this out. Nick, you're not in Indian Rocks Beach at the moment. You're actually in the Capitol, correct?
No, I'm home.
You're home.
I come home. I come home every weekend.
Oh, God bless you.
Even if it's I come home for 24 hours, I want to come home and
I say
obviously see my family. And
I say that to say this, and Nick, it means the world to us that you took an hour to be part of the show to do this during that limited time. But they're in session right now, Kevin. The legislators are actually working now on proposed legislation, and it's no small task how much effort and time it takes. I was talking to other state senators when they were trying to get their bills filed before the deadline. So I do want to point that context out. Nick's time is at an all-time premium right now with session being active. So, Kevin, any additional thoughts or questions for the senator?
There is the Senate Bill 1244 kind of tracks along the same thing, but that's I want them to look at it. But I know down here they do have a big problem with the short-term rentals and the partying, and they need something in there to give some teeth to these poor people that don't want a motel right next to their house.
Well, okay, so Kevin, let's walk down that road a little bit further, okay? So you have a motel right next to your house, but it's a motel of very well-behaved, polite, ordinance-obeying renters. Are you okay with that?
Yes.
Okay, that demonstrates my point. The real problem here is behavior, and I think that, and this would kind of be my thought, Nick, and so when you talk about the remedy in the legislation, I do want to circle back to parking, because parking was the other big sticking point in the town hall meetings in Indian Rocks Beach, and your legislation actually addresses parking, but I do want to talk about sort of the remedy. I mean, the remedy under 280, as I read it, you have the option of filing lawsuit for injunction, and there's a provision in there about mandamus. So are you saying that the new Senate Bill 280 would actually give the private property owner the ability to bring action against local city government to enforce the ordinance against the vacation rental? Is that sort of the reason there's a mandamus provision in there?
Yeah, that is a good question. I could say, in relation to that parking, trash, and noise, and this is something that, we've been hearing a lot of feedback about as well. The bill currently says that if you're going to regulate parking, that regulation has to be consistent across the entire municipality. And I know folks get frustrated with that, but I can tell you that is a position that essentially comes from the House. I mean, that is a position that they're not willing to move on. It becomes kind of the framework, the initial framework, just because that's important to them. And the reason for that is very simple. If, let's say, in any one of those three elements, noise, parking, and trash, if you regulate noise restrictions for one property and not for the other, that could ultimately be used to prevent that vacation rental from operating. Maybe you've got a law enforcement parked in front of the house with a noise meter, and boom, you're getting a fine, you're getting a second fine, and ultimately, depending on what currently that local ordinance says, that license or registration could be removed, and then that vacation rental property is now not operating at all. And I think that's really where the concern from the legislature comes into play, because we want to make sure that if you're passing an ordinance, that should be applied uniformly across the jurisdiction.
This is sort of equal protection light. So these are not constitutional rights per se, but we want a law that applies to our point and discussion earlier, that applies to all behaviors. If you had someone who had lived there 50 years flooding the driveway and the street with 30 cars every weekend, that's a problem. It doesn't matter that they've lived there and it's their homestead property and not a vacation rental. There's a behavior issue. So I think that's sort of what you're addressing there, and I think that's a fantastic point. Kevin, any final thoughts for the senator before we move on to the next caller?
I think he's on the right line. I grew up on Anna Maria, and the problem we have out there is what you talked about. They built these McMansions, 8 bedrooms, 5 baths, and 15 cars are parked on the yard and the street, and that's one of the biggest gripes I hear from my friends still living out on Anna Maria Island.
Yep. It's a problem, and Nick's working hard to try to get some sort of resolution. So, Kevin, we appreciate you being part of the show today. Thank you for calling in.
Thank you, Nick. Thank you.
Thank you.
You're welcome. All righty, 877-943-9673. Joining us on our hotline is Senator Nick DeCiglia, the author of Senate Bill 280, our new proposed legislation, which is currently in committee right now. Actually, it's a committee substitutes and what we call reference review. Is that correct?
Yeah, so it's been through the first 2 committee stops in the Senate. So there were only 2 references from the president's office, and now it's ready to get on the floor. And then again, we were, in the Senate, the House in the House. House amendments, floor amendments are not very common, but in the Senate we're very comfortable in filing floor amendments. So I would anticipate another amendment as we get it prepared for the floor.
All right. So if you have a question for Senator Nick DeCiglia regarding Senate Bill regarding vacation rental, Senate Bill 280, 877-943-9673. Again, that toll-free number, 877-943-9673. I'm Attorney Patrick Smith, and this is the Attorney Patrick Smith Show. All right, let's go to Indian Rocks Beach, Nick, and we're going to talk to John. John, welcome to the Attorney Patrick Smith Show.
Good morning.
Hey, John, how can we help you today? You have a question for the Senator?
Yes, absolutely. He referenced that this bill has something to do with constitutional rights, but a number of us have bought homes in areas that are zoned residential, and they've been turned from nice, quiet residential neighborhoods into hotel districts. And just as an example, on your street alone, Harbor Drive, we have 40 transient lodgings now. If you take a look at the number, instead of the 80 or so residents that used to live there, that brings even at 70% occupancy, brings over 20,000 strangers up and down these narrow roads every year instead of the 80 people who live there.
Well, it's going to bring out more now. You just told them the street I live on, John.
Well, we can find that out on the internet anyway.
Fair enough. Go ahead.
You're a celebrity. So, anyways, this is, how can this possibly be a constitutional right? If you think that a person can do anything with their property they want, then you believe there's no such thing as zoning. And our zoning has been destroyed, and this bill is just a giveaway to Airbnb. It won't even be enforced in terms of the database for 2 years from now. And right now, Indian Rocks Beach is spending $63,000 a year with host compliance to find out people that are illegal, find out the people that are tax cheating. That's how much it costs. And they're going to have the Florida division that's understaffed and underfunded do this for the entire state of Florida with hundreds of thousands of people. You know, the local businesses, the local cities can do this properly and effectively, and having the state supposedly do it, the division do it, it's ridiculous. It just won't happen.
All right, Nick, I'll let you respond first, and then I'll go after you. Please, Nick.
Yeah, so there's a couple things I'd like to unpack there, and thank you for your question, John. Number one, the state preempted this issue again back in 2011. So, this bill doesn't, all of a sudden allow vacation rentals to start popping up all over in our communities. They're already there. And so, to an earlier point, if a property owner, for example, wants to rent their property 4 months out of the year, and then they live or they want to use that property themselves for the rest of the year, the time that they're renting that property, if there's no violation of local ordinances, the noise, the parking, the trash, or anything else, in my opinion, for local governments to come in and say you cannot operate your property the way you see fit, I believe that is a violation of a property right. So there's that. As far as enforcement, this bill clearly lays out what a local registration program looks like. As is currently today, local governments can coordinate that with local law enforcement if there's violation of local ordinances. There's a trigger for a suspension of that registration, which then would turn to a potential suspension at the state level. As far as the database, we don't currently have a very adequate database, in my opinion. We don't require at the state level every single property have its own unique license number. That unique license number, in coordination with the state database, is going to make it incredibly easy for local governments to pull up an address and reference and see whether or not that address is, in fact, a vacation rental property. And if it is, there's a license number that's associated with that. And with that license number, there's a contact. There's a person that if in fact there is loud noise at 11:30, which is past the noise ordinance, there's going to be a contact that's going to be required to address that issue at that very moment. And so, again, to create that consistency, I'm not so convinced that some of these local ordinances are being enforced in an effective manner as it is.
Nick, I'm going to jump in. And just, John, I want to ask a question. If it was a long-term owner, and we got to wrap up the show here quickly, so I'll ask this question. I'll need a brief response. if it was a long-term resident, 30-year homestead property, and they had, 30 cars in the street every week, overflowing trash, and they were putting out loud parties every night till 3 in the morning, would that somehow be okay because it's not a vacation rental?
No, it wouldn't be okay.
Right.
But the fact of the matter is that doesn't happen.
Right. But, okay. But if it did, we can agree it's the behavior that's the problem. Really what we're trying to legislate here is the behavior.
No.
We're not. Okay.
No, we're trying.
All right.
You bought into a residential neighborhood. It should be residential. You shouldn't have 20,000 strangers driving up down the street.
John, I got to let you go. We got to wrap up the show, but I appreciate you calling in. I think it's a behavior issue, Nick. I really do, and I think that's where you get this law that applies to everyone, because everyone has to follow these behavioral rules, whether or not they're a vacation rental or not. And then everyone can live peaceably amongst neighbors and people who want to visit our beautiful community. And I do think, from a drafting standpoint, I'm not a legislator, but when I read it, food for thought, I thought a little more teeth as far as enforcement. I really don't understand the mandamus thing, but I do want to ask you one other question, Nick, before I let you go.
Sure.
Any predictions on New Hampshire?
Well, look, I think the polling is pretty clear. It looks like, Donald Trump is gaining some momentum. He had a huge night in Iowa. I think he's the favorite in New Hampshire. Obviously Nikki Haley and Ron DeSantis, depending who wins second or third, it's, Donald Trump certainly, is the man to beat at this moment.
Well, what's the mood like in Tallahassee after Iowa? I just want to know that.
Look, we were really laser focused on, the second week of session. Obviously, we were all watching what was going on Monday night. I think, there were some polls that had the governor third. Of course, he came in second. But at the end of the day, I think there was, no surprise that, that Donald Trump won Iowa. And, we were ready to get to work, 8 o'clock on Tuesday morning with our committees, our bills, and everything else that we're, required to do in the legislative session.
And Nick, to that point, we appreciate all the hard work and all the effort and all the criticism you guys have to go through doing this job. And, I want to thank you again for being part of today's show. We will follow the progress of Senate Bill 280, and you always have an open line to our show. Any legislation you want to discuss in the future, you always have an open opportunity, open invitation to be part of the show. So keep an eye on Senator Martin for me, too, if you don't mind. And
well, it's easy. It's easy to keep an eye on him.
Yeah, all 6'10" of him. Yeah, he's pretty easy to pick out in a crowd. So, Nick, really thank you so much for being part of the show.
Appreciate it. Thanks for having me today.
Yeah, thank you. Bye-bye. All righty, this is the Attorney Patrick Smith Show. I'm Attorney Patrick Smith. The office line, for those of you who thought I forgot, 877-754-6764 to reach me at the office for your free estate planning consultation, 877-754-6764. Everybody stay safe. God bless. Have a wonderful weekend.